Thanks everybody again for coming. My name is Karen Kuprys and I'm the Secretary Treasurer for the Alberta Federation of Labour, and I'm very pleased to act as a moderator for tonight's events. This event is being presented in a Zoom webinar format and on Facebook Live. So I'll ask a few questions of the panelists and give them time to answer, and we'll take questions from those who are watching as well. If you have a question, please write it down in the question and answer function at the bottom of your screen, and we'll do our best to answer as many as possible. So on behalf of the Alberta Federation of Labour, I want to thank you for taking the time to spend the next hour or so with us to hear more about Bill 81 and the implications of this legislation tabled by the Jason Kenney government and the United Conservative Party. Our time together is brief this evening, but I do want to start with a land acknowledgement. The Alberta Federation of Labour respectfully acknowledges that we're located on Treaty 6 territory in central Alberta, a traditional gathering place for diverse Indigenous peoples, including Cree, Blackfoot, Métis, Nakota Sioux, Iroquois, Dene, Ojibwe, Saulteaux, Anishinaabe, Inuit, and many others whose histories, languages, and cultures continue to influence our vibrant community. Treaty 7 territory in southern Alberta, the traditional treaty territories of the Blackfoot Nation, Siksika, Piikani, Kainai, and Tsuut'ina, and the Stoney Nakoda First Nations, including Chiniki, Bearspaw, and Wesley First Nations, as well as the Métis Nation of Alberta, Region 3. And Treaty 8 territory in northern Alberta, a traditional meeting ground for many Indigenous peoples. The territory provided a traveling route and home to the Cree, Dene, Inuit, as well as the Métis and many others. We recognize the history of oppression of First Nations, Métis, Inuit, and all other Indigenous peoples in their traditional land across Canada, and we are committed to doing the ongoing and active work of reconciliation. The Alberta Federation of Labour also recognizes that we are all treaty people and with treaty obligations, and are committed to continue living in accordance with the spirit of intent of peace and friendship that is foundational to the treaty relationship. As a labour movement, we will actively work together in solidarity to end oppression and seek justice for all peoples of this land. And thank you for that. And allow me to introduce our panelists. So I'm going to start with Professor Young. Lisa Young is a professor of political sciences at the University of Calgary, where she is currently director of graduate programs at the School of Public Policy. She holds a BA in political science and economics from the University of Winnipeg, and a master's in political science from Carleton University, and a PhD in political science from the University of Toronto. Dr. Young's research has focused on Canadian politics, including women's involvement in politics, election finance, and political party organizing. Thank you, Professor Young, for joining us. We also have Mike Parker. Mike Parker has served as the president of the Health Sciences Association of Alberta since 2016. He's been a first responder since 1992 and became a paramedic in 1999. He's been involved in the labor movement for many years, serving first as a steward and then a vice president of his local with the Canadian Union of Public Employees. He became a member of HSAA in 2009 and served on the board before being elected as vice president in 2015, and he is now president since the year following. And we also have Gil McGowan. In 2021, Gil McGowan was re-elected to a record two-year term as president of the Alberta Federation of Labour, Alberta's largest union advocacy organization, representing more than 175,000 workers in both public and private sectors. So again, thank you, everybody. And we're going to start the evening off with Gil. We have a full evening, but I just would like Gil to start by providing us an explanation of Bill 81 and what impacts this legislation will have on the AFL and unions specifically.
Well, thanks, Karen, and thanks, Professor Young and Mike, for joining us as well. If you're here with us tonight, it's because you've heard some nasty things about Bill 81, and those nasty things are true. This is a fundamentally undemocratic piece of legislation. But to provide some background, I think it's important that we recognize that it is not out of character with this government. In fact, if there has been one thing that's been consistent with the Kenney government since they won election 2.5 years ago, is that they have gone out of their way in many ways, both in terms of their rhetoric and also legislation, to suppress dissent and silence their critics. So we saw that right out of the gate with the now infamous Bill 1, which ostensibly was about protecting pipelines, but it snuck in some language that could be used to criminalize protests. Specifically, they said that they defined public spaces like sidewalks and public squares as critical infrastructure, and that if people gathered inappropriately, according to the legislation, in those places, they could be arrested if they so-called impeded people. So it was a law to criminalize protest, and we in the labor movement saw it as particularly targeting unions in the event that we were to get involved with large strikes. It would have been used against us. It hasn't happened yet, but they have the power. After that, shortly after that, we saw the government introduce the now infamous inquiry into so-called anti-Alberta energy campaigns. And yes, that seriously was the names of the campaign, better known as the Allen Inquiry. And it was designed to demonize environmental groups, Alberta-based environmental groups who were raising concerns about the fossil fuel industry and climate change. And not everyone agrees, but those are legitimate issues and legitimate concerns. But the UCP went out of their way to demonize anyone who dared to challenge the oil and gas industry, and sort of claiming that, suggesting very clearly that they were anti-Albertan. And then, of course, there was not this summer, but the previous summer, there was Bill 32, which was an attack on unions through changes to our labor law. In particular, it laid out provisions to essentially defund unions, especially in our political action work. So Bill 81, I think, needs to be seen in that context. It's a continuation of an attack on unions in general, civil society in general. And so, but specifically, I mean, the bill itself is long, it's 250 pages long. It's an omnibus bill, which means that it makes changes to multiple pieces of legislation. But for our purposes, I think the most important changes included in Bill 81 have to do with the changes made to what a piece of legislation called the Election Finances and Contribution Disclosure Act. And that's a mouthful, but it does two big things. First, Bill 81 creates a backdoor mechanism that had previously not existed to get big money back into politics. And specifically, they do that by removing the caps on donations that could be made to nomination campaigns. And they were quick to say, well, we're still keeping a limit of how much nominations campaigns can spend, which is $12,500, I think. But they could get unlimited contributions. And the result was that if a nomination campaign raises excess money beyond that $12,500, they can forward it to their party, and without having to deal with any kind of contribution cap. So this makes a mockery of the promise that the UCP made when they introduced Bill 81. They said this was about reducing big money in politics, but it actually does the opposite. So that's and critics have focused their criticisms, like pundits, political scientists. They focus their criticism on that aspect of the bill, and we understand that. But if that was the only problem with Bill 81, it would be bad enough, but it's not. From our perspective in the labor movement, we're also concerned about what we're describing as a democracy gag law that's included in Bill 81. And it works like this. Basically, it's a restriction on the activities of civil society, including unions. And it basically says that if you want to run a public advocacy campaign that criticizes the government in any way, either the government itself or its policies, and if you intend to spend more than $1,000 on that campaign, then you have to register as what they call third-party advertiser with the chief electoral officer of Elections Alberta, but then that's one thing. I mean, we have nothing to hide in the labor movement. I think most other civil societies don't. So civil society groups don't have anything to hide either in terms of their campaigning. But what this bill does is basically say that in order to register as a third-party advertiser, you have to jump through a bunch of hoops. And basically what they're saying there's a section of it amends section 9.1 of the Electoral Finance Contribution Disclosure Act, and it basically says that you cannot register as a third-party advertiser if you're deemed to be an affiliate of an existing party. And they have a list of things that the chief electoral officer will look at to determine whether you should be deemed an affiliate. So for example, it says that if you are mentioned in the founding documents of a registered political party, you will be deemed affiliate and therefore ineligible to register as a third-party advertiser. That's aimed at the AFL in particular, because we're mentioned in the New Democrats constitution. It's a recognition of the fact that the labor movement helped establish the NDP and that we continue to be the voice of labor. And it's basically just a tip of the hat to us. Doesn't give us much power. It gives us a couple of seats on their provincial council and a couple of seats at convention. But that's the extent of it. But because we're mentioned in the NDP constitution, even in passing, we are deemed ineligible to register as a third-party advertiser. And without being eligible to register as a third-party advertiser, we will be breaking the law if we run public advocacy campaigns, even if those campaigns are issues clearly of interest to workers, like labor law, occupational health and safety. Now, if that was it, it would be bad enough, but it actually gets worse. It basically says a civil society group will be deemed to be an affiliate of a party if they have people in their civil society organization who also hold positions within a party. Even if they're doing it on their own free time, even if it's not at all connected to their work in the civil society group, you'll be deemed an affiliate of a party and therefore ineligible to register as a third-party advertiser, which means you won't be able to run advocacy campaigns. The final one, which is the real kicker, is that a civil society group under Bill 81 will be deemed to be an affiliate of a party and therefore ineligible to register as a third-party advertiser if they have criticized the government. So here's the irony, right? So they say that if you want to run a public advocacy campaign that criticizes the government, you have to register as a third-party advertiser, but you will not be allowed to register as a third-party advertiser if you have criticized the government. So this is what I would describe as authoritarian pretzel logic. And it's clear. I mean, this is, they have spin and they have justifications, but when you cut to the chase, this is about silencing critics of the government, especially groups that represent working people, and tipping the playing field in favor of the deep-pocketed supporters of the UCP. So we think that this is fundamentally undemocratic. It violates the constitutional protections for freedom of speech and freedom of association, and it also will limit the range of voices that people hear going into an election. So for us, I mean, what we're saying in the labor movement, well, first and foremost, we're trying to raise the alarm about this legislation. And help people understand that this is not just about attacking unions. It's not just about elections. It's about silencing the voices of civil society on issues of important public issues that should be heard on the public stage, not just during elections, but in between elections as well. And so, we're determined to stand up to this legislation and make sure that the UCP is not allowed to take civil society out of our democracy.
Okay, thanks, Gil. The next question is for Professor Young. What are your thoughts about how Bill 81 affects our ability to advocate for issues? And do you feel that this threatens the ability of civil society to participate in the democratic process?
Okay, well, thanks for the question, and thanks so much for the opportunity to be here tonight. When I was invited, I said I will say yes to just about anyone who wants to talk about election finance law, and so I'm happy to have the opportunity tonight. I think that when we think about the rules about who can participate in elections, especially as third parties, it's really useful to think about, okay, why would there be any restrictions at all? And you can make a case for some kinds of restrictions, right? And particularly during the election period, right when that election's going on, you want the attention to be on the parties and the candidates, in particular. But there's certainly and there's been lots of discussion of this in the Canadian courts, right? Because it's very contentious. But one of the things that I think is really important when we look at how those laws are written and what their impact is going to be is the idea of fairness, right? So what the value that the courts have said are really important in regulating these sorts of things is this idea of fairness. And I'm actually going to read a quote from the Supreme Court of Canada in their decision in a case about this. It was Harper versus Canada. And the court said, promoting electoral fairness by ensuring the equality of each citizen in elections, preventing the voices of the wealthy from drowning out those of others, and preserving confidence in the electoral system are pressing and substantial objectives in a liberal democracy. And I think there's a lot to unpack there, but what I really want to focus in on here is this idea of preventing the voices of the wealthy from drowning out others. So if we look at what this bill does, it says that during the election period, the period from January 1st until May, when the election is going to be held, assuming that it's held on schedule, the only third-party advertisers who can advertise are those that take donations only from individuals. And that actually, you can make an argument for that, right? Elections should belong to the people who vote in those elections. But the maximum donation that is allowed is $30,000. And there aren't many people who have $30,000 available to give to a third party themselves, and that's where I think when we think about taking unions and corporations out of the conversation, okay, fine, but are we really empowering citizens to act, or are we creating the opportunity for the wealthy? So that $30,000 limit really worries me. So that's one piece. The second piece is part of what Gil was talking about when he talked about what's going to be required in order to be able to register as a third party. And looking at the wording here, I think is it's really very worrisome, because we can certainly see how it's important for the legislation to make sure that third parties aren't just a way for parties to spend extra money or raise money from other sources, right? We don't want third parties to be a way for the political parties to evade the law. Fair enough. But when we look at the wording here about who can actually participate, the legislation says that the chief electoral officer should look at whether groups have made public statements in support of or in opposition to a registered party. And so, as Gil says, what that looks like to me, interpreting that legislation, it's saying that if you've been critical of a political party in the past, if you've said the governing party has done things that we don't think are right, then it may be impossible to register as a third party advertiser. And that's, I think, hugely problematic. And when we think about civil society organizations like Friends of Medicare, who have been critical of government policy, is it going to be impossible for groups like that to raise money from individuals, register as a third party, and be active in the election? And I would be very worried about legislation that gets in the way of that. And that's what this legislation seems to do.
Thank you. Next question is for Mike Parker. Mike, HSAA is a registered third party and has been running a very large campaign. And so I want to give you the opportunity to just briefly describe the campaign and why it's important and how Bill 81 may affect campaigns like this and others.
Great question, Karen. Thank you very much. And thank you for the invitation. I want to talk about two campaigns that are kind of ongoing, actually. We are running a substantial campaign currently called I Heart Public Healthcare, focused specifically on protecting the jobs and the work that our members do within the public sector. These are the healthcare positions all over Alberta Health Services. We have roughly 19,000 members that currently work at AHS. The other campaign that's running significantly right now is an EMS resourcing campaign, where we're talking a lot about our paramedics and their inability to get to responses in an appropriate amount of time. These are two significant campaigns that we are running because our members want us to do it. These are issues that are critical to their work, to their life, to their job and their families. And so as the leadership of the union, absolutely, if we can find the space to run campaigns to amplify their voices, to ensure that their concerns are heard by other members, by the public, by the government. These are all political pieces because the decisions that were made to reduce resources, to privatize our healthcare system, didn't come from an employer. They came from the government. And to speak specifically, the government is actually at the bargaining tables across the province in public sector work. So if the government has influence at our bargaining table, then we should be able to have influence in politics. That's where I see things here. We've done some great work on enhancing the CPP, and it wasn't against any one government party. We took exception to every government party federally that wouldn't move forward on an enhancement to the CPP. Same conversation here. When you look at childcare, it's not done yet. We need a lot more work to amplify what access to childcare really means. It's political to do it. It's political work by applying political pressure, because they're the only ones that will make the changes that are needed. You can't get an employer. This, again, amplifies their voices. These are the members' concerns. It is their resources, and it is our work to ensure everybody hears what they're saying. Here's some losses in the fights that we've taken on. To stop the privatization of plasma collection. Lost that one, legislation written to monetize our plasma collection. Currently, over 3,000 of our members sit poised to be privatized as lab workers. Got something to say about that too. That's the protection of our members on issues that are important to them. It's political. And sometimes you don't speak in favor of the government. There are times when maybe you will. Still waiting for that time with this current government, but I hope that answers a little bit of the question, Karen, on how this is going to prevent us from representing our members in a way that they are asking us to do.
Absolutely. Thanks for that answer, Mike. Next question is for Gil. Gil, I'm going to combine a couple questions, and being cognizant of time, I have a few questions for each panelist still, and then there's some questions in question and answer. So first, so bear with me, I'll put the two together. You had mentioned in your opening statement that, well, there was a lot to unpack in your opening statement, right? And it's a huge bill, but some would argue that there's a need to take big money out of politics. And so do you feel that that Bill 81 achieves this? And also the UCP has taken great pains to brand this bill as one that closes the AFL loophole. And we've heard tonight that this bill is much broader, has a much broader reach than just the Alberta Federation of Labor, and I'll ask you to comment on that.
Thanks, Karen. So the first question is about the importance of taking big money out of politics. And if that's the goal, then we in the labor movement have made it very clear that we agree. We don't want to see happening in Canada or in Alberta what we see happening south of the border, where it is much more of a Wild West situation. For anyone who's spent time in the United States or even just watched American TV, you see what happens around election campaigns. People are inundated by expensive ad campaigns paid for by friends of the various parties. They spend literally billions of dollars to influence voters in the lead up to their elections. it does sort of take the individual citizen out of democracy and put people with big money in the driver's seat, and that distorts democracy. And so when during the previous government here in Alberta, when Rachel Notley and the New Democrats were in power, one of the first things that they did after winning the election in 2015 was to prohibit corporate and union donations. And I was president of the Federation of Labor at that time. And after consulting with our affiliates, we were very clear. We supported that because we understood that big money in politics distorts democracy. And so we supported that. The problem, which the New Democrats were very cognizant of, was that once you prohibited corporations, especially, because frankly, they always donated way more than we did. But once you put those prohibitions in place, there was all this money that had previously been spent on donations to parties that was looking for a home. And they were very concerned that with all this money sloshing around Alberta's political stage, there would be a move towards the creation of American-style PACs or political action committees that would fund third-party advertising. And in fact, that's exactly what happened. So in the lead up to the 2019 election, most famously, the car dealers of Alberta got together and they funded a big American-style PAC called Shaping Alberta's Future. They spent about $2.2 million on ads that became ubiquitous. Everyone saw them. You couldn't go anywhere in Alberta without hearing about how bad the Notley carbon tax was, or hearing ads about the so-called Notley Trudeau alliance. And not surprisingly, their message lined up very, very well with the UCP message. It was clear that they were trying to get the UCP elected and Notley defeated. So there was something that needed to be regulated here. So the New Democrats introduced the first version of the Election Finance Disclosure Act, mostly to focus on disclosure and transparency. And we weren't opposed to that either. We didn't have anything to hide. But while it's important, so the question is, should we regulate third-party spending during elections? And the short answer is yes, we should, but we should do it carefully. In particular, we think that there is an important distinction to be made between the work done by legitimate civil society groups on one hand, whose job it is to hold governments accountable, and there's a distinction that needs to be made between them and purpose-built political advertising committees that have only been created and only exist to support or oppose one party or another. A perfect example is the Alberta Federation of Labor versus this car dealer funded Shaping Alberta's Future. We've been around since 1912. We've been advocating for workers' interests right from the beginning. And while we support a party, we are not the same thing as a party, right? Whereas Shaping Alberta's Future didn't exist. It was created overnight as soon as the auto dealers had raised $2 million to pay for these ads. And we need rules for third parties, but they need to make a distinction between groups like ours, a legitimate civil society group that has an established interest, in our case, protecting workers' rights, and these fly-by-night American-style PACs. And unfortunately, Bill 81 does not make that distinction. And so, they claim that this is strengthening democracy, but it actually does the opposite. To your question about the AFL loophole, that is just political spin. It's true that the Alberta Federation of Labor and most of our unions support the New Democrats, but let's be honest, the employers and wealthy people have their own party too. And in Alberta, that's the UCP. So no one should be shocked that working people are supporting a party that supports working people. When I hear Jason Kenney and Casey Madu and other UCPers complaining about how unions tend to support the NDP and not the UCP, my answer is, well, if you don't want us to be hostile to you, if you don't want us to criticize you, stop attacking working people. It's as simple as that. And so instead of actually trying to support working people, they're trying to silence us, and that's where it becomes undemocratic.
All right, thank you. The next question, again, Professor Young, you made some comments about the issues of fairness in relation to Bill 81. And just wondering if you could make a few more comments about whether or not you think this is a balanced or fair approach to a participation in the democratic process.
Sure. And, you know, fairness is such a tricky concept, right? You know, it can be very subjective. So we always have to be careful. But, you know, the first thing I'm going to say is that we know that citizens value the idea of fairness, right? Jared Wesley from U of A and I have been doing some survey work of Albertans and asking them questions about what they think is important in elections. And the number one value that comes out is that they should be fair. And so there's, when we think about fairness in election law, there's a phrase that we hear all the time, and that's a level playing field, that the political parties should compete on a level playing field. And so a lot of the attempts, you know, that Gil has talked about here to regulate third-party expenditures or third-party activity during elections has been in the interest of fairness. And the idea of fairness there is that citizens are actually best served if they get to hear from all interested parties, not political parties, but from many different voices, particularly at election time. Now, those voices shouldn't drown out the political parties, but anyone who has something that they want, a message that they want to convey during an election, in that view, you know, they should have an opportunity to do that. And we have to set rules up so that one set of voices can't drown out another set of voices just because they have greater financial resources available to them. So that's part of the reason that there's been such an emphasis on how much you can spend. Now, this legislation gets us into this question of how much you can actually contribute, right? And so we need to then start asking the question of whether some of the limits on contributions are actually intended to limit how much you can speak or how much you can spend in the election. So that's, you know, it's another sort of complicated set of questions. But you know, I guess what I would say is that when I look at this legislation, I don't think that it promotes fairness in the sense of making sure that voters are able to hear from many different voices and that those voices can't be drowned out by the affluent. And I'll come back again to the idea that an individual can give up to $30,000 to a third-party advertiser to spend during an election, during the election period. And you know, I think that does get us into the territory where we need to be asking questions about fairness, whether some citizens' voices are going to be able to drown out other citizens' voices.
Okay, thank you for your answer. Mike, this is, I mean, it might seem obvious, the question, but do you think that HSAA would be, that they would really be heard about their concerns in the public without the ability to run these campaigns? And you mentioned a little bit about it, but what do you think what do you hope that the impact of the campaigns are when you run them?
First, I'm going to comment to Lisa's statement on the $30,000, but yes, thank you for the question. I want to be crystal clear here. My membership is concerned about things like the utility bills they can't pay or car insurance. This is the reality of this. That's what working class folks look like. And when Lisa is saying 30K is a top limit, I mean, that would drain the entire retirement savings of half of the membership that I represent. So let's be crystal clear here on what $30,000 means, okay? Absolutely unbelievable. If the ability of our members' voices cannot be amplified through the work of their union, and again, this union is as democratic as it gets. I get elected every 2 years. And so if I'm not doing what they want, I'm out the door. And that's how it works here. And so when they say, union, we want you to stand up for childcare. Union, we want you to stand up for seniors care or pharmacare or any pieces that are critical to society like this. We're not talking about just our members as an inclusive piece. When we fight for pharmacare, it's for all. And that's the battles that we take on every day. And what this does is it risks that ability. It starts taking away my ability to ensure that their voices are amplified. And what we're doing now is we're going to put workers against corporations. Let's be crystal clear. The Labour Party, the NDs, were built over 70 years ago by the labor movement, because we didn't have a voice in government. There was nobody in government speaking on our behalf. So what did we do? We created a party to send them forward to go speak on our behalf. Same thing today. So to tell me that if I speak for one party or against another party, I am now aligned in a pact with that party. I just want the party that's going to help me take care of my members. That's what I'm looking for. And this is an absolute abomination of what it's taking us down the path here. I'm not even
Thanks, Mike.
the question was that you were asking. Did I answer?
It was fine. Your answer was wonderful. Thank you, Mike. I'm going to take some questions out of the question and answer box now, and I'm going to combine them a little bit. This one is for Gil. Has the AFL or other organizations published an analysis of Bill 81? And is the AFL talking to the media about what Bill 81 really is?
Yeah, I wish the answers to that last question was easier, and I'll get to it. But in terms of your first question about an analysis that you can read, the short answer is yes. We have solicited legal analysis from experts. So Leanne Chawley, who is a well-known lawyer here in Alberta, who has a lot of expertise in election finance law, wrote a legal opinion about Bill 81 for us, and it has been made available to all of our unions. And so when I provide a critique of the bill, it is largely based on her analysis. And like I say, we've shared that legal analysis with all of our affiliated unions. For the broader public, we have boiled it down into a little bit more of a readable format. So if you go to the AFL website, www.afl.org, we just this morning, we posted quite a lengthy blog dealing with an analysis of Bill 81 and what we think it means. So I would encourage you to read that and share it if you have the time. I also wrote a guest column for the Edmonton Journal today, which is even shorter, only about 650 words. If you haven't seen that, it's our attempt to boil it down to its essence. So those things are out there. In terms of your question about the media, yes, we have. This bill was introduced on November 4th. It's like 3 weeks ago now. It's still in front of the legislature in second reading. And right from the beginning, we put out press releases, we called reporters, and there were, as far as I could tell, there were two stories, one from the Journal and the Herald, the Post Media, and then one from CBC. But neither one of them really dealt with many of the things that we're talking about tonight, the important nuances of the bill and its implications for civil society and fairness and democracy. It was really just paint by numbers coverage saying the bill was introduced, here's what the government says about it, here's what the opposition says about it, and that was it. And so, I'll be honest, I don't think that the media has done a particularly good job of explaining to Albertans what this bill actually says or what implications it will have for our province. But, the reality that there's a lot of bills in front of the legislature, there's a tiny press corps at the legislature. They're doing their best, but it's a 250-page bill, but it's only one of many. So it's hard, right? And so that's why we're having this webinar tonight. That's why we've written the blog. That's why I wrote the guest column. We're doing our best to raise the alarm. And I'm pleased to say that as of today, we are getting a lot more attention. I think we've alerted a lot more people to this bill, but there's still work to be done. Unfortunately, the UCP has made it very clear they're committed to this bill. They've got a majority. They're going to pass it. But as a labor movement, we've committed to challenging it. We think it's a clear violation of the Constitution and its protections for freedom of speech, freedom of association. So it's not a question of if this will be challenged. It's a question of when. And we're going to do everything we can as a labor movement make sure that the UCP doesn't get what they want, which is a constriction of the range of opinions being discussed on Alberta's political stage. They want to take civil society out of democracy, and we're going to do everything that we can to make sure that they're not successful in that effort.
Great. Yeah, I appreciate all the information in your answer there, Gil. So this is for any of the panelists, but I'm going to actually ask Professor Young to start off the answer, and if anybody else wants to contribute an answer, please do so. Does this mean that the AFL, does this mean AFL affiliates are going to be not able to do public advocacy, or just the AFL? So affiliates of the AFL, are they going to be able to do advocacy, or is it just the AFL they're trying to stop doing advocacy? And in addition, what constitutes criticism of the government?
Yeah, that's a really good question. So the first part of that question is I think a little bit easier than the second part. The question, they absolutely, the government has been very clear that they're closing the AFL loophole in their views, and so there are provisions in the law that talk about having a formal relationship with a political party, and so Gil has talked about that, and so I think that is unique to the AFL in that sense. But there's more to it than that, and that's where we get worried for other organizations, right? Affiliates or civil society organizations that want to be involved in politics. And the tricky thing here is that the way that the legislation is written is it says these are things that the chief electoral officer should take into account when they decide whether somebody, an organization, can register as a third-party advertiser. And so it's possible that a chief electoral officer would have a very narrow interpretation of this and let everybody, with probably the exception of the AFL, register. But there's no guarantee of that, because this argument of this wording of take into account could also be interpreted quite broadly, and that's the worry, right? You don't want the legislation to be so ambiguous that that a civil society organization that has been critical of government, regardless of who's in government, worries about whether they can then raise money and advertise during an election, right? So there's huge ambiguity here, and it puts an awful lot of discretion in the hands of the chief electoral officer, which I don't think, it certainly worries me to see that much discretion there.
Yeah, and actually one of the other questions in the chat is along the same line, so I'll ask it. Would this open the door to stopping the general public or an individual in criticizing the government? Not necessarily running campaigns, but does it inhibit the ability just for individuals criticizing?
Yeah, I don't think so. I mean, what I see here, and I'm just going to go back to the wording, to the extent to which the third party has been involved in, has made public statements in support of or in opposition to the registered party. So what worries me there is if, I looked at this and I thought, okay, what's a civil society organization that's been active in third party advertising sometimes? Let's think about Friends of Medicare. So I went to the Friends of Medicare website, and right there on the first page, there were a couple of statements that criticized the UCP government, right? So it named the party. And then when I look at that and I look at this wording, I think you could certainly make a case that, under this legislation, Friends of Medicare, because it has been critical of government, or it has been critical of the party in government, might then be said to be affiliated with a party. And that's, not at all, I think, what is the intention of restrictions on third-party advertising. But again, the amount of discretion here. But for individuals, I don't think there's any reason to think that there's a restriction of individual freedom of speech.
Yeah, if I may just add to Dr. Young's answer in that regard, I agree that this legislation will not restrict the speech of individuals. where it kicks in is when individuals or groups want to spend money, and the threshold for spending, unlike the threshold for donations, is actually quite low. So if you spend $1,000 then or more, then you have to register as a third-party advertiser if you're running any kind of campaign that is critical of the government or government policies. And that's a very small amount of money, right? And what they're basically saying is that if you want to use any of the tools of 21st century public advocacy, whether you want to create a website, run ads on Facebook or YouTube, basically do any of those things that we've all become very accustomed to in terms of what we'd expect from advocacy groups. If you want to do any of that, you have to register as a third-party advertiser. That's when these rules kick in. So whether it's Friends of Medicare or the Council of Alberta University Students or the AMA or environmental groups, all of them would because they're usually spending more than $1,000, they would have to register as third-party advertisers. And what they're trying to do is take away the tools of modern advocacy away from their critics. That's troublesome to me. And the other thing that I think is really important is this notion of deeming, right? So in section 5.1 of Bill 81, it says that groups will be deemed to be affiliates of a party if they criticize the other party. And so that might be news to a lot of Albertans who are very critical of the UCP, but they don't hold the party membership in any party. But if they run a campaign or spend more than $1,000 criticizing the UCP, they will be deemed to be New Democrats, essentially. And then because they're deemed to be New Democrats or in league with affiliated with the New Democrats, they won't be able to register as a third-party advertiser. So yes, that will affect the AFL. Yes, that will affect most of our affiliates. But it will affect people from across the political spectrum. I mean, this is a really unpopular party right now, and the UCP. And so it's like 80% of Albertans could be deemed under this legislation to be affiliates of the NDP, even though only a fraction of them would actually be that way. So, I mean, and the point I made in one of the points I made in my guest column today is that, deeming anyone who criticizes the government to be an affiliate of the other party, that's an authoritarian tactic, right? You see that in authoritarian countries. It's like you're either with us or against us. And then setting up the chief electoral officer as the gatekeeper and the commissar of what constitutes acceptable political speech, that's also smacks of authoritarianism. And neither one of those things have any place in a true democracy. And that's why I think people should be very worried about this piece of legislation.
So I saw you lean forward, Mike. You
I
have
was just going to say, I find a couple of things on this. What happened to the last electoral officials that weren't walking the right line with the current government? I believe they, they got fired, didn't they? Yeah, that's how it works, apparently, if you don't fall in line.
These guys are impervious to irony.
What I want to talk about are, and I think I've expressed enough about the frontline healthcare system and the members I represent, but let's talk about an issue of any parent. Save Our Schools has been fighting for the last 2 years. They have spoken out against the government. Childcare Now has been fighting for a generation to get access to childcare, spoke out against the government. Protect Our Province are giving daily COVID updates to ensure Albertans hear really what's going on the front lines of healthcare. And they are critical of the government. So let's be clear on how wide of a brush this truly is becoming as we look at the legislation after legislation that moves to silence the voices of those who are in opposition. And if they can't silence you, apparently they fire you. So this is the world we're dealing with right now. And it just, I'm curious, this is on either for us or against us. So what would happen if there was a legitimate, it's an American concept, totally, right? Two-party politics is exactly what that is. There's other parties in this country. Let's have a look federally. There's more than two, so for us or against us, but with them, a friend of my enemy, whatever the hell that saying is. Like, this is just bizarre. And you called it pretzel politics or something, Gil. I think you're close on that one for sure.
Okay, being cognizant of time, we have 6 minutes left. So I want to ask a couple of questions in combination. What would the consequences of disobeying the law and continuing political advertising without sanction from the chief electoral officer be? And is there, sorry, I lost the question in the box here, but is there an appeal process to the decisions?
These are questions that were addressed in the legal analysis that was put together for us by our lawyer Leon Chawley. And in terms of the fines, they can be substantial. So the legislation contemplates fines of $100,000, which, you know, when you're talking about multi-million-dollar campaigns like the ones that the auto dealers ran for shaping Alberta's future, we say, well, you know, $100,000 fine, that's just the cost of doing business. However, the question is how you apply them. So if we look at the CRTC that has similar rules at the federal level, when they apply their fines, which are about $100,000 maximum too, they apply them every day that you're in violation. And so the legislation is not entirely clear, but we're assuming that it would be applied in the same way. So the $100,000 fine would be every day that you're in violation. So if you continue a campaign or launch a campaign that hasn't been registered as a TPA, you could face fines of $100,000 a day, which is very, very substantial, right? So that's a huge impediment to you know, any group, even a larger group like the Alberta Federation of Labor, in terms of our ability to run a campaign in the public interest. What was the second question? I'm trying to remember.
About
Appeal process. There is no appeal process. The only appeal is to the courts. So there's no appeal process to Elections Alberta, but so we would have to take it to court, either as what they call a judicial review, where you take a piece of legislation to court and ask the courts to rule on the legislation, or you defend yourself once you've been charged. So those are, one way or another, we're probably going to end up in the courts on this. We're confident that we'll win, but in the meantime, we may be muzzled, and I think that might be their calculation, that they can muzzle us long enough so that we're less of a factor leading up to the next election. And I think that people have to recognize that this is a last desperate attempt by a very unpopular government that's circling the political drain. They're looking to stack the deck by silencing their critics in advance of the next election. And we're convinced that that's what this is about. And you know, whether or not we defeat this law in the courts, which I think we will, they're still trying to just do everything they can to tie us and other critics of the government in knots in advance of the next election.
Okay, 1 minute each for each of the panelists, just to round out our evening. But we have had a lot of good discussion on the far-reaching impacts of this bill. It's a huge omnibus bill, and it's very, very dense. But is there, one takeaway? I mean, there's lots of takeaways, but is there one takeaway that you would like to particularly highlight? And I'll turn it over to Professor Young first.
Sure. When we think about what makes democracy work, it's that the people trust that the process is fair. And I think everything that takes away from that, it really puts us in trouble. And we've seen, if we look south of the border, we can't take democracy for granted. So that's why I get so concerned about things like this. So, the ambiguity in the law that we've talked about, the potential that it will stifle the ability of legitimate voices to participate in the process, and an increased sense of unfairness, right? That the wealthy will have a disproportionate influence on the outcome of elections. And those are all things that I think take away from democracy, and as citizens, we should be worried about them.
Mike, over to you for a final comment.
I almost spoke while I was muted. It was that close. Okay. I want these comments to be addressed to all workers in this province when I say that we must continue to amplify our voices on concerns that are important. We must continue to encourage civil society to stand up, to defend the rights of workers, public health care, public education, Because if they are successful in taking down the voices that currently represent, the only voices left are those out there as individuals to rise up. They are the citizens of this province. They must recognize these ongoing attacks, and they must stand up and defend their right to democracy, as Lisa has clearly laid out. And Gil, thank you very much.
Thanks, Mike. The last minute is for you, Gil.
Okay, thanks, Karen, and thanks, Mike and Dr. Young, for a fabulous discussion, and thanks everyone for joining us for this evening. In conclusion, I'd just like to remind people that democracy is more than just political parties and candidates. In order to have a vital, vibrant democracy, you also need to have a vital and vibrant civil society. We've seen that over and over in Canadian history. Many of the things that have been won on the political stage were first won by civil society. The most recent example is the establishment of the first major social program, universal national social program since Medicare. Just a week ago, we saw the federal government sign an agreement with Alberta as one of the last provinces to create a national childcare program. That didn't happen because of Rachel Notley or Justin Trudeau, and certainly not because of Jason Kenney. It happened because of generations of parents and activists, pushing for this program. And we saw the same thing happen with Medicare, with CPP, with OAS, all the things that sort of define our country. They bubbled up from civil society. And so, what this legislation ignores, and honestly, what I think it actually distorts and undermines is the role of civil society in our democracy. And Canada is identified as one of the most democratic countries in the world, one of the only the Economist magazine has this thing called the Democracy Index, and only 23 countries in the world are what they consider full democracies. We're in that list right now, but for those countries that have fallen out of the definition of full democracy and fallen into what they describe as flawed democracies, these kind of laws are one of the reasons that that have seen countries fall from full democracies to flawed democracies, and we simply can't let it happen here. So this isn't just about defending the ability of workers and unions to speak out. It's defending the importance of civil society, and that's where. So I'll end tonight where I began by saying we simply can't allow Jason Kenney and the UCP to take civil society out of our democracy, because if they're successful, it will no longer be a full democracy.
Thank you, everybody. I want to say thank you to the panelists, and thank you for the participants for taking time out of your evening to learn about this, and we really appreciate that. My apologies if we didn't get to your questions. If you need further information, please feel free to reach out to the Alberta Federation of Labor, and everybody stay safe and warm and have a good evening. Thank you so much.
Thanks, everyone.